So what we have done, we have taken this mock exam from BPP. I think it is from BPP practice kit. It is given at the end of the BPP kit. So we'll do it together. We'll try to do it quickly and see if we can manage. So I will explain some logics wherever it is needed. So it says, in which of the following courts do all criminal cases begin? So remember that it has to be magistrate court, because magistrate court is for criminal cases, county court is for the civil cases, and crown court is above magistrate court. So those cases which are a little bit more, because it says all criminal cases. So if there is some serious crime, then cases are promoted from magistrate court to crown court. So if the question comes that, okay, because when you're doing one question, you should see the alternatives as well. So if it says that in which of the following courts do all civil cases begin, so you should have said county court. Because it is criminal, so it is magistrate court. And where is the crown court? It is above the magistrate court. Okay. Number two, so our answer is B option, magistrate court. John holds 100 shares in Box Limited. The directors of Box Limited have announced that she will be granted 1 share for every 5 shares that she holds. The share will be issued fully paid up. Fully paid up. Okay, now what should be the answer? Right issue, bonus issue, capital issue, special issue. It is an example of bonus issue. Okay. See, why do I say that? It is an example of bonus issue. Shares are, so when you have existing, when shareholders, they have existing shares, and based on their existing shares, there is some proportion like 1 for 5, 1 for 2, 1 for 3. Like here, it says that you already have 100 shares and you will be granted 1 share for every 5 shares that you hold, which means that you will get 20 shares. And granted, which means that you are given for free and they are fully paid up. So these are bonus shares. Right issue also has a similar type of statement, which says that 1 for 5 issues, 1 for 3 shares, 1 for 10 shares. But in case of right issue, you are given a right to purchase shares at a certain price. So you are not given for free. You are not granted the shares. You are not granted shares. You are granted a right, that you have a right, if you wish to, you have a right to purchase. And that price is lower than the market price. So it's a right. Okay, market price is $5. I give you a right to purchase 20 shares or 40 shares for $4. But now it is your choice if you want to buy at 4 or not. You may decide I'm not buying it. But in this case, it says granted shares. So when you grant shares, which means they are for free, you're not expecting cash, further cash from shareholders, and this is bonus. So you understand what is right issue. Right issue is not granting the share. Right issue is granting the right to purchase the share for cash. So this is not right issue. This is bonus issue. Capital issue is for anyone. Capital issue, in case of capital issue, anyone can buy. You do not need to be an existing shareholder, but it says that you already have some shares, and based on that, you are given the right or granted some shares. So capital issue is not the case, because for capital issue, it is not for the existing shareholders only, it is for anyone. And it is not a special issue as well. A special issue is again different. It's not for existing shareholders. Special issue is also for everyone. So here our answer was magistrate court. Here it was bonus shares. In the context of sources of law, what is a statutory instrument? Statutory instrument. Number one, remember statutory, the word statutory mean legal, and the word instrument a lot of times means a document. Instrument is actually any way or any method, but in most cases here we understand it as a document for a special purpose, a document which will achieve some method, and it has to be legal, statutory instrument. A tool used by Parliament in the process of developing primary legislation. No, primary legislation, no. Primary legislation is when you create the main law. And that is not made, cannot be made by special statutory instrument. A form of delegated legislation that allows ministerial powers to be exercised. A right granted by the UK's human right legislation. No, this is the answer. Option B. A form of delegated legislation. Delegated legislation means that somebody is given an authority to apply the ministerial powers. So that is called a statutory instrument. Which of the following is an indication that a person is self-employed rather than an employee? The difference between, or what differentiates or what distinguishes an employee from a self-employed person. So the person has the ability to delegate work to others. This is the person is a salary paid. No, this is an employee. That a person is a self-employed. So we are looking for a condition for self-employed. Okay, we are not looking for a condition of an employee or a staff member. We are looking for a characteristic of being self-employed. The person is told how they should perform their job. This is for employee. So this is employee. You are given a fixed salary or whatever. You are employee. You are being told how to do your job. You are employee. The person has their work tools provided to them. You provide the work tools. This is also a condition for employment, for your employee. This first one is a condition for self-employment. Self-employment means that I give a task. I have explained this in video lectures as well, that an employee is someone who comes at a fixed time, leaves at a fixed time, uses your workspace, you provide them with the tools, and you tell them what to do, you give them the job description, and they cannot give it to someone else. Like you assign a task to your employee, and then employee gives it to someone else and says, okay, I am free. No, 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 no. It's an employee, it's not employment then. In case of self-employment, which is called freelancers, like you say, okay, today in today's understandable language, we all have heard this word a lot of time, which we call freelancers. So a self-employed person is kind of a freelancer. So if I get a task as a freelancer from someone, then I can ask it to anyone to do it, and then I deliver the task. You cannot tell me that you have to do it yourself. I can give it to anyone in my team or maybe to outsiders. And you cannot tell me that you have to start at 9, finish at 10. I will do it anytime I wish to. And then you are also not giving me place or space to work. And you're also not, you don't need to give me any computer to do my job. I will do it with my own equipment, in my own place, at my own timing, and I can give it to anyone to get it done. This is the main difference between employment, employed or self-employed, okay? Which of the following is a condition that must be met in order for a principal to ratify the actions of an agent? So first of all, you should understand what is the word ratify. Ratify means to approve something which has already happened. Ratification, it occurs in laws as well. In many cases, ratification, it occurs in case of contract law. And forget about the word principal or agent for a moment, because principal and agent is not only necessary for ratification. If you understand ratification, then you can apply the same in many different cases. So what is ratify? Imagine, I have given this example in one of the video lectures as well, but maybe I need to, or I can repeat it again. Imagine I want to sell my car, okay? And I have put it is parked under my building. So I am party A, I'm seller, I want to sell my car. And I've given advertisement. So somebody came to buy the car. They saw the car and they don't know me. They just saw the car. And my neighbor was standing there. My neighbor was standing there. And I've given the ad, $10,000, the price or whatever. The person who came to buy the car, he did not know that he is the neighbor, he is not the owner. He talks to the neighbor, what is the price? And the neighbor said, oh, it is for 10,000. And he say, I agree, I will buy it for 10,000. Now, the buyer is making an offer to the neighbor, not to me. The buyer has made the offer, 10,000. I made an offer for 10,000. He has accepted 10,000. He said, yes, I will buy it for 10,000. Now, is there a contract between the buyer and myself? I was not there. Is there a contract? Yes or no? Now, here the ratification comes in. What happened that in 20 minutes time, in 10 minutes time, I also walked down to the place and I say, what is going on? And they said, oh, I made an offer to this guy. I said, oh, he's my neighbor. And I say, okay, I will ratify. I say, I ratify. So this event took place earlier. I came later and I ratify. Ratify means kind of approve it. So if I approve it or if I ratify it, I am the seller. If I ratify it, this becomes a contract. And the buyer cannot say that, okay, I'm walking away. No, he has accepted the offer. The contract is there. The contract is there. So ratification is done by me, the seller who has given the car or who is selling the car. In this case, I am the principal and my neighbor becomes my agent and the other party is the buyer. So ratification is where one principal, in case of me, I am the seller, and one agent, in this case, my neighbor. So I have to approve it. Now, in another case, for example, now you may ask, okay, what else could have happened? Maybe I came down, let's suppose, and I wanted $10,000. The buyer said, oh, I'm not willing to pay 10,000. I can only pay 9,000. So he made a counter offer. The neighbor said, okay, I agree with 9,000. I did not agree with 9,000. I actually wanted 10. But my neighbor who was standing by the car, he said, okay, I agree 9,000. And in the meantime, I also came to the scene. Now, is there a contract? Again, the contract will happen only if I ratify. Previously, I ratified. I said, okay, if he has made a deal with you, I'm okay with that. But in this case, I have a choice again. I say, oh, no. He said 9,000. I am not willing with this price. I want 10,000. So the buyer would say that, okay, but he just agreed with me. I say he did not have the power to agree. His agreement will only become valid if I ratify it. If I'm not ratifying it, if I'm not agreeing with this discussion, which is going on between you two, I'm not into the contract. So this is the concept of ratification, okay? Now, this ratification can happen in multiple scenarios, but once you understand what is ratification, then questions will become easy. So which of the following is a condition that must be met in order for a principal to ratify the actions of an agent? Ratification must occur immediately after the contract is formed. Ratification must be agreed with the third party. No. Ratification is done by myself. It not necessarily has to be agreed by the buyer. Buyer has accepted the offer. So if he agreed with 10,000, he agreed. We don't need to convince him any further. So this is not the condition. The principal must have existed when the contract was formed. This is also not the condition, because if I existed there and everything was happening in front of me, then there is no point of ratification. Ratification will only happen that something happened in my absence and I came later on and then I gave approval. So answer choice is A. What is the minimum notice period that a person who has been employed for 18 months is entitled to? It's 1 week. From 1 month up till 2 years, it is 1 week. Okay? 1 week notice from 1 month until 2 years. Okay. In the event of an unlimited liability partnership being terminated, so it's an unlimited liability partnership, which is a special type of partnership. No, it's not. Limited liabilities, LLPs are special. This is unlimited, which is normal. Being terminated, which of the following liabilities are repaid next once all external debts have been settled? So first you have to pay the outside debt. So this is like the sequence, or the order in which you have to pay the liabilities. Okay. Of course, first we have to pay the outside debt. So outsiders, everybody has been paid out. Now what is left inside? From here, we have to distribute it among the shareholders. Okay, we have settled with outsiders. Now this is the money which belongs to us, we four partners. So how do we take it? Who takes first? Number one, um, partners capital contribution, partners loan advances, partners share of profit. Okay, so it has to be loan advances. Always remember, first loan advances should go, because capital comes later on. I paid some money. So imagine that you and we are partners, and you give $10,000. I paid 10,000. Another Mariam paid 10,000. Nastasia paid 10,000. We are four partners. But then Nastasia also gave an additional $3,000 loan. So when we have to settle with each other, and we are saying bye-bye to each other, we are closing the business. First, Nastasia say, give me my 3,000 first, so that we all become equal. After that, we will talk about other things. Okay. So first, you should pay out the loan advances. This is the answer. Okay. You have to pick up one, but let me finish all of them. So this is the first thing which should go out. In the second place, the capitals should be paid out. And in the third point, share of profits will go out. Profits will be distributed in the end. So we've got this box of money. We will say, okay, first we gave money to Nastasia. Maybe there is nothing left in the box, so nobody will get anything. So she will take her $3,000, which she gave as an additional loan, and she will go home. And nobody will get anything else, because there is no money in the box left. Yes, if there is some money left, then we say, okay, let's start paying out the capital. So we paid out capital to everyone, and we said, okay, this is what you initially gave to the business, so please take out that one as well. And then if something is left, we say, okay, now this is what is left from the total profits. Let's divide this as well. So this is the sequence. First, always, it's very logical. First, loans should be paid out. Number 8. Every time I have to pick up my pen, so that's why I changed the screen. A declaration of solvency is required to commence which of the following? A member's voluntary liquidation, creditors voluntary liquidation, a compulsory liquidation, and administration. Okay. Declaration solvency is required to commence which of the following? A member's voluntary liquidation. Now, this is again, the topic is from company law and declaration, bankruptcy, etc. What is happening here actually? Liquidation of a business is when a business goes bankrupt, you liquidate it and you sell the assets of the business and you settle all the liabilities. This is what happens in case of liquidation of a business, which usually happens in case of bankruptcy. In some cases, it happens before bankruptcy as well. It is possible that the business is not bankrupt, but we decide to liquidate. It is also possible. Members liquidation means that the shareholders, who are the founders or the members of the company, they take back their money. They return back their share capital and they take their money. Let's suppose we are 4 people. So, by the way, we are 5 in this class. It's Ashwarya, Mariam, Saeed, Nastasia, and myself, Ali. We all own this company. We have invested a capital of $10,000 each. The business has a share capital of 50,000, and the business is going on. At any point in time, I say, I want to leave the business. So our company is not a public limited company. And I said that, or maybe it could be a public, does not matter. So we decide that the company will buy my shares. Company will buy my shares so that I can take my cash and I can walk away. So if this has to happen, what is needed is that the business need to make a declaration of solvency, which means that the business is sound, the business is solvent, business is not insolvent. Insolvent means a business which has liquidity problems, which has, some cash issues or some other issues. So you must give a declaration that business otherwise has no problem. You know why it is needed? It is needed because I said that give me my 20,000 or 10,000, I walk away. And that was with some bad intentions because I know that the business is in problem and I want to take my money before, and then the creditors and the bankers and the suppliers and the employees, they will not receive the cash because I took all the money and I walk out of the business. Imagine that I am the only shareholder. Imagine there are only two shareholders, not five of us. And you and I, we liquidated our things, we took major cash and we walk out of the business. And everybody is left there crying, though there is no cash because Mr. Ali or maybe Saeed has taken the money and they have gone. So if you want to do a liquidation of a member, which means that member wants to return the shares and get cash and walk out, before that, they must make a declaration that the business is solvent and this kind of liquidation, this kind of paying cash to this member will not disrupt payments to other parties who are the outside parties. Because you remember that the shareholders, they are the owners of the residual interest. Residual interest means after paying everyone, if something is left, that is given to them. If I take everything in before, that's not what is the definition of the the founder or shareholder. So before a member's voluntary liquidation, it is important that a declaration of solvency is given. Okay. Now you might have creditors voluntary liquidation. This is not needed. Compulsory liquidation, which means that the company has come into shape or into this form that this liquidation must be performed. If this must be performed, you don't need it. Whether you have it or you don't have it, you just have to do it. It's a compulsory liquidation. So this declaration is not needed. And administration. What is administration? Administration is that stage or is that process in which the court assigns the administrator to liquidate the assets of the business and convert them into cash so that liabilities can be settled. So this administration is something very serious issue. Nobody is going to wait for that. Compulsory liquidation, nobody is going to wait for that. Creditors voluntary liquidation, this is not required because this is the outside party. Okay. So this is answer should be a member's voluntary liquidation. Now, why I'm explaining you all of these options, because it is possible that when you will go to exam, so it is not necessary that exactly the same question will come. Another question might come, and for that question, the answer could have been this one, probably, or that one. So you need to understand. So it's just like you try to play with the question and see all these four options. So tomorrow when you go to exam, maybe a question which will come for that question, maybe this is true. Okay. So number 9. Which of the following is a ground for disqualifying a director under the model articles of association? Okay, so there are some now how to say terminologies which you need to understand. Is a ground for disqualifying a director under the model articles of association. Number 1, articles of association, we call it AOA. This is the founding document of the business. Okay. Articles of association is just like the rule book for the company. It is like the constitution of the company. Okay. So articles of association will define what the business will do and so on, and the rights and duties, etc. So articles of association, whenever a company is formed, you must have articles of association. The model articles of association means model is the standard. So the law give you some standard format that at least these things should be present in the model articles of association. If you want to add something more, remaining within the parameters of law, you can add. But at least this is what should be included, minimum. So this is the bare minimum terms and conditions. So model articles of association. So which of the following is the ground for disqualifying a director under the model articles? Like based on the model articles, disqualifying a director, which means that the director does not remain qualified to perform his duties. So director is like ousted from the business. The director is going away from the board of directors. Okay. So, I mean, one way of doing it, that directors are elected by the shareholders, and then in the next annual general meeting, again the voting will be done and you will choose, okay, he will be the director, she will be the director, and again election will be done. So one way of, directors are elected by the shareholders and then they are removed by the shareholders. But we are saying that directors are removed not by the shareholders, but because of some reasons based on the model articles, not by the shareholders, but some special action is taken due to some conditions in the model articles. And what could be that situation? That situation is becoming bankrupt. If the business becomes bankrupt. When a business becomes bankrupt, what does that mean? A business becomes bankrupt means that the management has failed to the directors, the board of directors, which is called management. Management means the board of directors. They have failed to maintain the business in the going concern format. So if they have failed to perform the duties, the business has gone bankrupt, directors should go away. Very simple. Now we are not waiting for the shareholder meeting and they will say, oh, I still want this lovely guy. No, he's going out. Breach of fiduciary duty. Fiduciary means legal. So if a director does not perform the legal duties or fiduciary duties which are to them, it does not mean that they become disqualified. We need to see what type of breach it is, how serious it is. In some cases, it could be a criminal case. So it is not just disqualification, by the way. If there is a breach of duty, which is so serious that it comes under the criminal law, so we are not just disqualifying the director and saying him, okay, you go home. Probably we are planning to send him to the prison. So it's not just disqualification. It could be, you might, the shareholders, they might say, okay, it's a breach of duty, but the director can continue and there could be some warning or there could be some other punishment, but he can continue. Disqualification of director is not there. Failure to meet a statutory duty. Again, the same things happen. Breaking the terms of their service contract. Again, the same things will happen. Here, there will be a choice. Either they continue or they go away. But in this case, they must go away. Okay, number 10. Which of the following companies qualify for exemption from audit? So qualifying for exemption from audit, which means that you don't need to do audit. Remember, public companies all must be audited. Public limited companies, which are called listed companies, which have shares on the stock exchange, all of them must be audited. Private limited companies, some can be audited and some cannot be audited based on the volume. Based on the volume. A public company with turnover of 1 million and a balance sheet of $2 million, it's a public company. It cannot be exempted. It must be audited. A dormant company This is the answer. A private company with turnover of 11 million and a balance sheet value of 6 million. No. Okay, dormant company is a company which is not performing any activities. It is possible, and I have seen it in my real life, that we created a company and the company has some assets, but we have kept it dormant, which means that it does not have any other staff members, it does not have any office, it is just present on the piece of paper, it is not buying anything, it is not selling anything, and there is only one director which we have kept there for the purpose of signature we will use when we'll finally want to close the company. So at least one physical person should be there, who in the event that finally you said, okay, we are closing it, so when you have to close it, somebody has to stamp it, somebody has to sign it, so you need at least one person. But because the business is not doing any operations, it is called dormant. If it is dormant, it does not require an audit. Okay, so it says exemption from audit, dormant. Private companies also can be exempted from audit, but in that case their turnover should be um, not 11 million. I think it is 10.2 million or something. 10.2 million. And the assets on the balance sheet, something like 5 million or something. I don't exactly remember because these things that keep on changing. So at least this is not 11 million. This I know, because there was some point 10.2 or 10.1 or something like this. It was not an absolute number. And plus, I know that if it is a dormant company, so when I actually saw the question, I even did not read it because I know that I have to choose one answer, and that one answer is this one. All other things cannot be the answer in the presence of dormant. Because dormant company came in, I said that's the answer. How many days holiday leave, including the bank holidays, is an employee entitled to as a minimum? As a minimum, 28 days. 28 days is the minimum period which an employee is entitled in 1 year's time. Leah was recently dismissed from employment when her employer found out she was pregnant. Which of the following types of dismissal is this example of? This is clearly a case of unfair dismissal. Remember, you cannot dismiss people based on, number one, this pregnancy. I'm not calling about other medical conditions. Pregnancy is also a medical condition. But what dismissal is related to thing, you cannot dismiss an employee because of pregnancy, never. You cannot dismiss an employee because of their religious beliefs, never. You cannot dismiss employees because of their ethnic beliefs, never, never. If you do it, it is called unfair dismissal. And the employee will be reinstated. If the employee goes to court, the court will decide that the person will go back and start performing their duties. You cannot remove them. This is unfair. Wrongful dismissal is a situation where dismissal is possible. It should have been done. It should have been done, but it was not done in the proper way. Maybe you did not give the notice, maybe you did not provide the sufficient reasoning or evidence, maybe you did not give the compensation. So wrongful dismissal is like the dismissal is okay, but the method which you adopted for dismissal was not okay. So the employee remains dismissed, but the method which was adopted was not okay. Okay. Unfair dismissal means that the dismissal itself is wrong. And then a constructive dismissal. I have explained this thing also in the topic lectures as well. Yes, Mariam, I will answer your question. Just give me a minute. Let me finish constructive. Constructive dismissal is that, we exactly actually know in companies that, I want to fire some person, but I cannot because I don't have any reason to fire him. So, and plus, if I fire him, if I dismiss him, probably in many countries, you have to pay some additional compensation. So if I fire you, I have to pay you some compensation. But if you resign and walk away, I don't have to give you any compensation. Okay. So I want you to go, but I don't want to send you. I want that you come in and you throw resignation on the table and you say, I'm going. I say, yes, please go. Thank God you decided. So how it will happen? I will make your life tough at work. I will create such conditions which will force you to give resignation. I will put extra pressure to you. I will assign you some different jobs which are not in your job description. I will try to create such conditions which will create frustration for you. And then you come back and you are in, probably you are emotional, you are angry, you are frustrated. You go back to your desk, you write down the resignation, you come back to me and you say, this is the resignation, I'm leaving, I can't stand it anymore now. And I'm very happy that you are leaving. So actually you did not want to leave, I made you to leave. This is called constructive dismissal. When you will go back home, and then your anger will cool down and your frustration will go away. And then you will realize, oh, I made a mistake. Mr. Ali, he just played with me. So you have a right to go to the court and say that although I resigned, but it should not be considered as my resignation. It was actually a constructive dismissal because he created those conditions for me. And then you have to prove that, this was my job description, but this is what he was asking me to do. And this is what my, work conditions, and these were the work conditions which were promised to me, and this is what he was giving to me. And the court will find out that did you resign or did I force you to resign constructively? That is called constructive dismissal. So we are talking about pregnancy. When I saw the word pregnancy, I immediately knew that it was unfair. It is not wrongful and it is not constructive. Then we continue. Okay. Number 13, we are doing in the context of contract law, what is the effect of a counter offer on the original offer? Counter offer immediately cancels the original offer. I said, I'm selling my car for 10,000. This is my offer. You say, Mr. Ali, I'm willing to pay 9. When you made a 9,000, that's a counter offer. Now I say, no, I don't. No, I don't agree with 9. And you say, okay, let me agree with 10. I say, no, it's over now. Because when you made a counter offer to me for 9, my offer is already gone. Now it is your offer 9,000, which I have declined. So once I declined that 9,000 offer from your side, because I made an offer to you 10,000, you did not say yes. You said 9,000. So my offer is gone. Now you have made a counter offer 9. I said, no, 9 is not, it does not suit me. And then you come back and say, okay, I'm willing to pay 10. I say, sorry, I don't want to sell you. You will say, but you just made me an offer for 10. I say, yes, I did make you an offer, but you did not accept it. You did not give an acceptance. You made a counter offer. So once you made a counter offer, original offer is gone. So acceptance of the original offer is as it stands, no. So rejection of the original offer. A counter offer means the rejection of the, because I said 10 and you said I give 9, it means you are rejecting this thing. So once you have rejected it, it's gone. Number 14, holding companies may give directors, just picking up my pen, it is such a stupid thing. Every time I have to scroll, I have to choose this pen thing. Holding companies may give creditors of their subsidiary companies a letter of comfort regarding the ability of the subsidiary to pay its debts. So holding companies like the parent company, the big one, they do have some smaller entities which are called subsidiaries. So subsidiaries, they deal with the suppliers. So this is the holding company, which is called the parent company. It might have some small companies which are called subsidiary companies. Sometimes the subsidiary companies are small ones. They are not very well known. So when the supplier want to deal with them, or the banks want to give credit to them, they somehow look to the parent, that should we give them credit? Do you give us guarantee? So holding company, parent company, many times it gives guarantees or letter of comfort to the other parties that, okay, no worry, you give them credit. If something happens, I am here, I will pay. This is letter of comfort, okay? What is the legal effect of a letter of comfort? What is the legal effect? It is legally binding on the holding company only. It is legally binding on the subsidiary company only. Not only, because there are two parties involved. How can you make one party only? Because supplier came, talked to them, and then supplier talked to him. So both parties, this is taking money, this is guaranteeing money. How can one party be responsible? One is taking, the other one is guarantor. So how can one only be responsible? It is just like Mariam wants to take loan from the bank and Anastasia says, okay, I am the guarantor. So then who is responsible? One or two? Both of them. So it is legally binding on the holding company and the subsidiary company. It is not legally binding on the holding company. If it is not legally binding, why do you give it? Then it is a piece of paper. So these are gone. Both of you are responsible. Okay, in relation to the tort of negligence, which of the following describes the standard of care expected of individuals? Now, what you need to understand, you know that tort, these are the small cases which happen between people, you know, law of tort will apply. We say that standard of care expected of individuals. Standard of care means that we say that every individual, they have, you know, an expected duty. We call it duty of care. Duty of care means that, okay, it is my responsibility, but you also have some duty of care. You also need to protect yourself, okay? If you see that, for example, there is some construction work going on, and they have put some sign that there is some construction work on the road or whatever. So it is their duty to make sure that they protect the area so that people do not get hurt or people do not get injured. So the company which is doing that thing is responsible for taking certain measures. But as individuals, do we also have some duty or not? Or should we allow ourselves to go and fall into that ditch or fall into that area and get ourselves hurt? We also have some duty of care to protect ourselves. So, and that duty of care is like a reasonable thing. We don't say that it is an extreme condition which can be expected from you. Here it is always what a reasonable person would do in the circumstances. What a reasonable person would do in the circumstances. They would try to protect themselves reasonably. They are not experts. They are not skilled. They are not, some superhumans, but at least what a human being should do. For example, if you are crossing the road, don't you have a duty of care? So, okay, others have a duty, others have to stop the car on the zebra. But if you see that a car is coming fast and it is already quite close to the zebra crossing, and you say, because it is zebra crossing, I must walk, what will happen? There will be an accident. So I know that the car has to stop on the zebra, but the car has already come so close to the zebra crossing that it cannot, the driver, could not have even stopped even if they tried to. You also have a duty of care to see that it is coming fast, it is very close, I should wait the car to go and then I will walk away. So that is called duty of care, which everybody has. So in tort of negligence, so we said that there was a construction thing was happening. So probably you said that the other party did some negligence, and because of their negligence, I got hurt. The other party will say, okay, but you also had some duty of care. And what is that? What can be reasonably expected of them personally in the circumstances? Personally, which means that what they would have done. No, it is not about what they would have or should have done. What the person is actually capable of the circumstances. We don't know the capability of individuals because all individuals have different capabilities. What is actually possible to do in the circumstances, we don't know what actually was possible. We say that what a reasonable person would do in that circumstances. What a reasonable person would do. Okay. So we have done 15 of these. Okay, there are quite many of them. Number 16, what is the effect of voluntary non-fit injuria in the law law of tort? It is a complete defense to an action in negligence. So these are the rules in the law. Voluntary non-fit injuria, complete defense. This is the answer. It reduces the amount of damages that a defendant is liable for. It reverses the burden of proof so that the defendant must prove that they were not negligent. So the burden of proof from the claimant to the defendant, it has reversed. So this is not. When you say voluntary non-fit injuria, this is when it is a complete defense to an action in negligence, which means that there is some action which happened in negligence. So either you accept it or you said or you reject it. It is not about sharing the, how to say, the consequences. It is not reducing it. It is not reducing the damages. It is just, I didn't do it. It was not my fault. So the other party, you are transferring the entire thing. In bankruptcy cases are heard by which one? So it's bankruptcy. Bankruptcy is coming from the company, and civil, it is by Chancery Division. Family Division goes for family cases. Queen's Bench goes for criminal cases, but Chancery is which goes to the bankruptcy and company and civil. In relation to the general rules of statutory interpretation, which of the following is the rule that states to express one thing is by implication to exclude anything else? Which means that when the law is made, the rule was created, or the language of the law is like if you include one thing and that automatically exclude the other. Expressio unius est exclusio altris. This is the answer. I remember it like that. Express something to exclude alternatives. In my English language, I would read it, express something which excludes the alternatives, which means express one thing and exclude anything else, which means exclude alternatives. Noster and solis or in pari materia. In pari materia is when you have some multiple laws and you need to see that, okay, what the parliament made laws in the past, and based on the past laws, you interpret the current law as well. Which of the following contracts will the Consumer Right Act 2015 apply to? Consumer Rights Act 2015 will apply to the supply of commercial goods from one business to another. Supply of commercial goods from one business to other. It is not specifically from here. A contract made in relation to family law, totally excluded. It is not consumer right. This is not consumer right because it is one business to another business. So this is between business to business. So consumer right will not apply. This is family. Consumer right will not apply. An employment contract law will go. Employment contract, it is not consumer. Only this one is left. A mobile phone contract from a telecommunications company to a private individual. Private individual is a consumer. So consumer law will apply. In this case, it is business to business. This is B2B. So consumer law will not apply. This is family issue totally. This is between a company and his employee, not a consumer. And this is actually a case of B2C, which you call business to consumer. In negligence, what is the limit of defendant's liability for damages? The losses the full losses incurred by the claimant, the losses that the defendant could reasonably foresee, and the amount of losses that the defendant can afford to pay. Afford to pay is absolutely not logical, because I mean, I only afford to pay you $1. Does not make sense. The full losses incurred by the claimant, full losses. This is not also, because claimant can come in and ask anything. If a claimant comes in and says, give me $1 million, does that mean I should be $1 million? No, it should be the losses that the defendant could reasonably foresee. Reasonably foresee what could have happened. That is something for which he should be made responsible to pay. So it's not that what the defendant has the capacity to pay. It's not about your capacity to pay. It is also not about my desire, what you should pay. So if I am the claimant, you are the defendant. So it's not about what I'm asking, and it is not about what you can pay. It is about that what possibly could have been in that situation. And then the lawyers will fight the case that what is the reasonable foreseeable thing? What could be the reasonable estimate foreseeable? In many cases, you will, when you go down to, when you try to understand these things, a logic or rational, you could see that there is some logic coming in. For example, if there is a claimant and there is a defendant, so the claim, does it depend on what the defendant can pay? Of course, it's not about what you can pay. You might come up and say, oh, I've got only $1. Take this $1 and go away. It does not make sense. Or the defendant comes in and says, give me $1 million. That also does not make sense. So only this one is left. Which of the following parties does a company auditor owe their duty of care in respect of their audit report? Which of the following parties does a company auditor owe their duty? So company auditors are doing audit for whom? I mean, they have a duty of care, and that duty of care is for the members personally? No, it is not about the members. They are not serving the members' interest. The directors? No, directors are just employees. They will leave tomorrow. The creditors are only one part of one group of the stakeholders. There are other people as well. So they have a duty of care to the company as a whole, because they audit the company accounts. Okay. So it's not about members. They are not responsible to show a duty of care towards members or directors or creditors. It's about the whole company, because they audit the whole company. Terms may be implied into a contract of employment if they have certain characteristics. Which of the following, if a characteristic of a term that may be implied into an employment contract? That may be implied into. First of all, you understand what does that mean, imply? Imply is an English language word. Imply means something which has not been said, but it is understood. For example, if you ask me that, Mr. Ali, can we meet tomorrow? And I say that, Said, tomorrow I'm very busy. So did I say yes to you or did I say no to you? I did not say either yes or no. I said, you asked me, can we meet tomorrow? And I said, tomorrow I'm very busy. So you can imply that we are not meeting. So imply means that to believe something, to understand something which has not been explicitly said. So which of the following, if a character of a term that may be implied into an employment contract? The term must be acceptable. The term must be proportionate. The term must be practical. The term must be notorious. Terms may be implied into a contract of employment if they have certain characteristics. Okay. Practical, proportionate, acceptable, notorious. Answer should be the option D. The term must be notorious. If a characteristic of a term that may be implied into an employment contract, it has to be the term that must be notorious. that can be employed into it. Which of the following is a lawful excuse for not performing the contractual obligation? So you are not, now you know that you have to perform the contractual obligations. So under what circumstances your excuse can be accepted legally, lawful excuse? The cost of performance has increased from when the contract was formed. No, that is not a lawful because you agreed. So the contract was not made surely a guarantee to profit you. If the cost go up, the cost might go down in some cases. So this is not an excuse to non-performance of obligations. You must perform it. Performance is made more difficult due to unforeseen circumstances, and the other party has made performance impossible. This is lawful. The other party has made performance impossible. You created some conditions under which I cannot work. The other party, because these two, performance is made more difficult due to unforeseen circumstances. If you take these type of things, then nobody is going to perform the contract. Whenever they find it less profitable, they will leave it. Whenever they find it challenging or difficult to do, they will walk away. So if you take these two things, only profitable and easy contracts will be exercised. All other contracts will be, left in the middle. Answer is this: the other party has made performance impossible. I want to perform my obligations, but you have made it impossible for me to perform it. Could be a construction contract. A certain contracts may be made orally. Yeah, verbal contracts are possible, but are not enforceable unless they are evidenced in writing. Which of the following contracts must be evidenced in writing? So, verbal contracts are contracts, it is possible, but some contracts, they are necessary to be in writing. They must be in writing. A lease for more than 3 years, a conveyance contract, a contract to provide conveyance, a contract of guarantee, a promise not supported by consideration. Okay. A promise not supported by consideration. Consideration means what you give in return. So in many cases, it is cash. So there is a promise, but that promise is not about cash. A promise could be, okay, I will, provide you a table. Probably tomorrow I do not. You can still live with that. But if I say I'll give you $1,000 and I don't give, you cannot live with that. So a promise not supported by consideration. So you don't have to make it in writing. It could be a verbal thing. I mean, if it has to be in writing, it must be. If it has to be supported by cash or by consideration, it has to be written. A contract of guarantee must be written. A contract of guarantee must be written. A contract for providing conveyance, no need to write it down. A lease for more than 3 years, mostly it is written, but still it can go in verbal form as well. But this contract of guarantee, it cannot go in a verbal form. It has to be written. Okay, number 25. In a company with more than one member, what is the quorum for a class meeting? A company with more than one member, what is, maybe two, maybe three, what is a quorum of a class meeting? Two persons who hold at least a third of the nominal value of the shares in the class, three persons who hold at least half of the nominal value of the shares in the class, 5% who hold. Answer is 2. Answer is 2. Because when it says that more than one member, it means that it could be 2. So all companies with 2 members, they fall into this criteria. If the company has only 2 members, how can you bring in 3 people or 5 people? logically it is gone. In many cases, you actually can see that without even knowing the law or the legal side itself, the logic fails. Okay, so I mean, if this is a question, this question can be solved by anyone without having any knowledge of business law, because I mean, logically it is not possible, because you say that more than one member means two people company, and there are so many companies which have two members. So if you have two members, can the law says that at least three people should come? Where will you bring the three people? Or five people will come? Okay. Number 26, where a compulsory liquidation order has been granted. So compulsory liquidation is given by the court. It's not voluntary liquidation. Which of the following is true? An insolvency practitioner is appointed as liquidator. Not insolvency practitioner, you have administrator here. Insolvency practitioner is appointed by the company. But when you have a compulsory liquidation, it is in the court. Administrator will come in. This is not the answer. All employees are automatically dismissed. This is true. When a company is going through compulsory liquidation, the court has given order, there is no purpose of keeping employees. Company is going away. You are just arranging the funeral. So you don't need to have any employees in the company. They are all automatically dismissed. You know, dismissal of employee is a very technical thing, because you know that constructive dismissal, wrongful dismissal, unfair dismissals, you need to think before you dismiss someone. But in case of this one, everyone is gone immediately. And then they cannot go to the court that my dismissal is unfair, my dismissal is wrongful. No, you are dismissed. Everyone is dismissed. Any legal proceedings against the company that are in progress at the time of liquidation order are allowed to continue? No. All legal proceedings, they are stopped. A lot of businesses, they go into bankruptcy. Actually, they file bankruptcy. I mean, this compulsory liquidation happens in very extreme cases. In many cases, businesses file bankruptcy. They file bankruptcy to protect themselves against 20 different cases. For example, if you are a company which is facing a lot of challenges, you are not able to pay to your suppliers, pay back your bank loans, to your creditors, you cannot meet the obligations towards customers, everyone is taking you to the court. And you as a company have to face 50 different court cases in 50 different courts. To get rid from all of them, you say, I'm filing bankruptcy. The moment you file bankruptcy, all of these cases are closed and they are combined. And everybody is told, please go back and sit down and wait. The company has filed bankruptcy, and then the outcome will decide. It will be liquidated, assets will be sold, and you will be given whatever it is. So all cases, it says, are allowed to continue. No, everything goes at a halt. Employees, you go home. Creditors, you keep quiet. The company's directors continue to run the company. What running the business? It is under liquidation. You cannot run the business while the liquidation is going on. You cannot simply. Besides, there are not any directors there. There are not any employees there. It says the directors continue to run the business. No, directors are employees. They are also terminated. Everything is gone. So answer is employees are automatically dismissed. This is the answer. Number 27. Which of the following is a rule for valid consideration? Okay. Rule for valid consideration. Okay. Consideration must pass from the promisor. Consideration must be adequate but not necessarily sufficient. No, this is not a rule. It says valid consideration. It must be adequate. No, there is no such rule that it must be adequate. There should be a consideration. A consideration could be $1, okay? Performance of the promise must be possible. A promise must be given in writing. So this is not necessary. Promise must be given in writing is not possible, is not the option. Consideration must be adequate. No, not necessarily. There has to be a consideration. For example, I'm selling you my car for $1. Car cannot be $1. It is not adequate, but I'm selling it. Consideration must pass from the promiser. This is also not necessary. Answer is performance of the promise must be possible. So whatever is the promise which has been made, that is possible. Okay. Number 28, which of the following is the final court of appeal for a number member Commonwealth countries? For member Commonwealth countries, it is the Privy Council. You just have to remember it. There is nothing to explain. It's Privy Council for Commonwealth countries. Final court of appeal. It is not the Supreme Court. Supreme Court is for one country. It is not the court of appeal. It is also for one country. It is Privy Council. Number 29, which of the following is a right of the holder of a debenture that is secured by a fixed charge? Okay, what is a debenture? Debenture is also called as bond. Debenture is an instrument. It's a piece of paper which is given by the borrower to the lender. It's bond. When you will go to your other papers like F7 and F9, you will understand in more detail what is a bond or debenture. So it is like an evidence of, you can say that it is an evidence of taking loan. Okay, it's a debt instrument. Otherwise we call it a debt instrument. For example, if you take loan from some party, from someone, you have to give him some evidence. That piece of paper is called a bond. It is called a debt instrument. It is called a debenture. Okay, secured by a fixed charge. Now that is a piece of paper. So if you are, if you come in or you take a loan from someone for $10,000 and you give them that piece of paper, which is called a debenture, in the end, it is a piece of paper. What is the guarantee that when the time of payment will come, I will bring that paper to you and you say, I have no money? Then what will I do? It is just a piece of paper. You put your signatures, but what do I do with that? It's just a piece of paper. So in order to make this piece of paper secure, which means that, okay, when the time of payment will come, the payment must be made. So what you do, that you say, behind that debenture, there is some asset, maybe a building, maybe a house, or maybe a building. So if at the time of payment, the borrower does not honor that commitment, does not pay that money, the holder of the debenture, the person who has the debenture, they have a right to go and sell this asset and recover their money. So secured. We call secured loans and unsecured loan. Secured loan means a loan which is supported by some mortgage, which is supported by some asset or so on. And it is a fixed charge. You have floating charge and you have fixed charge. A fixed charge is on fixed asset, immovable asset, like a house, like land, maybe an office premises, maybe property. It is against fixed charge, means against fixed asset. A floating charge means that not on one specific asset, not on one particular asset, not on this house, not on this premises, but anything from your assets. If you don't give me money, I will take something from your assets. So that is called floating charge. Floating charge is weak because asset is not nominated. When you have a fixed charge, you are very secure, because as long as I do not pay this money, I cannot sell the asset. Asset has a fixed charge on that. So fixed charge is always a very solid thing. So you want, as a lender, you always want to have a secured financing, that whenever I'm giving money, it has some guarantee at the back. And the best form of guarantee is always a fixed charge. Floating charge is a weak charge. Because why I'm telling you floating and fixed charge difference, because you might get it in some other future MCQs as well. Okay. So which of the following is a right of the holder of a debenture that is secured by a fixed charge? Um, See, this is given here. To prevent the company from selling the asset. This is what I was saying, that fixed charge means that as long as the loan is not settled, this cannot be sold. You cannot sell it. To prevent the company from selling the asset secured by the charge. This is the answer. So it says that, so the question is actually that what is the right of the holder for a fixed charge? The right is that the company cannot sell the asset. This is fixed charge. In floating charge, you can. Okay. Payment of a company, dividend, oh, what it has got to do with dividend? To vote at the company general meeting? No, because this is debt. The providers of debt, which are called the lenders or the creditors, they are not shareholders. They do not attend the board meetings. Board meetings are by shareholders. So this is not possible. To vote on company, they cannot because they are not. Vote on company's resolution. I did not even read it full. I only read to vote. How can a debenture holder vote? Votes are done by the owners of the business. Voting is done by the owners of the business, and owners of the business are the shareholders. Lenders and creditors, they have given the money to the business, but they don't vote. They don't have a right to vote. So voting is gone. Dividends are gone because dividends are given on shares, not on debentures. Remember, when you take a loan, you must give some interest, but that is interest. That is not dividend. Okay. Dividend is only given on shares. Interest is given on the debentures. Answer is this one. Which of the following statements concerning the Consumer Right Act 2050 is not correct? Is not correct. A term that restricts a consumer's legal right is void. Oh, is not correct. Okay. A term that restricts a consumer's legal right is void. No. A term that allows the business to unilaterally alter the terms of the contract is void. No, because this is actually correct. The question said is not correct. Pay attention to these questions. They're always confusing. Actually, this statement is correct. This statement is correct. But they are not asking us which are the correct statement. This is also a correct statement. They're asking us which is not correct. So this actually confuses you because when you see it, you say, yeah, this is correct. Oh, yeah, that is also correct. But they're asking you which is not correct. The term that is deemed unfair cannot be enforced by the consumer. That is not correct. Okay. So 30 we have done.